There is big news in bankruptcy this week because the Supreme Court has just granted certiorari to decide a fourth bankruptcy case in the term that will end in June. This new case is called City of Chicago versus Fulton, and it's what I fondly refer to as the Chicago parking ticket cases. This is a very important bankruptcy case, probably one of the most important bankruptcy decisions that the Supreme Court will have handed down in several years. It deals with the question of how automatic is the automatic stay. Said in other terms, the court is going to answer whether inaction, that is, not acting, can violate the automatic stay. Here is how the case came up from the Seventh Circuit in Chicago. The City of Chicago pays something like 7% of its city budget through parking fines, and they are really tough. If you don't pay your parking fines, your car is impounded. The bankruptcy judges in Chicago, however, uniformly held that once a debtor files a Chapter 13 petition, the City of Chicago is obligated by a combination of Section 362 automatic stay and the Section 542 turnover provisions to give the car back immediately and automatically to the debtor without even requiring the debtor to file a petition for a turnover in the bankruptcy court. The Seventh Circuit upheld the bankruptcy judges. However, there is a split of circuits because, among other things, the Third and the Tenth and the DC circuits have held that inaction, or that is, not acting, does not violate the automatic stay. Those three circuits hold that there must be some affirmative act to violate the stay. But as I said, there is a split because four circuits have held that inaction, or the refusal to act, is a violation of the stay. This is going to be a very important decision for a multitude of reasons because of the implications of how the Supreme Court rules. If they say, for instance, that doing nothing does not violate the stay, then, for example, a garnishment that a creditor obtains before bankruptcy is going to stick, and it's going to force the debtor to go either to the bankruptcy court or to the garnishment court to vacate the garnishment, and that costs debtors lots of money. Perhaps their retainers they pay their bankruptcy counsel is not going to cover actions like that. And as a result, what's going to happen is, if the Supreme Court rules against the debtor in Fulton, creditors are going to get away with things that they to date have not been able to do. We will be reporting more on this case as it progresses. I suspect that the briefs will be filed in the winter, and the argument will probably be either in March or in April, and that means we should have a decision around the end of the term in June. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. We will be back same time next week with a report on something significant that has happened in the world of bankruptcy.